You follow the case involving the 2014 murder of Dan Markel closely. In 2023, you intently watched the murder-for-hire trial against Charles Adelson, the victim's former brother-in-law. You are aware that Dan Rashbaum, the defense attorney, and his team pulled out many surprises at trial. One of those surprises involved jury selection. A full team of jury selection experts, including nationally known jury selection defense attorney expert Joshua Dubin, better known as Josh Dubin, filed an appearance just before the start of jury selection. And Josh Dubin conducted the questioning for the defense. You wondered if these tricks would work, if Charles Adelson would get away with murder. You heard that jury selection was done, we had a jury, and then you watched the trial every day, looking forward to the result. The verdict came, and you learned that dentist Charles Adelson was found guilty of all charges and was going to spend the rest of his life in a Florida prison. A few days later, you learned that Charles's mom, Donna Adelson, was also arrested for the murder. Late September of 2024 can't come fast enough. That is when jury selection will start for her trial. If you're the person I just described, this new video, part of a new series, is for you. In this series, you will watch never-before-seen excerpts from Charles Adelson's trial, from jury selection to the trial itself, key portions of the trial that also include audio of the sidebar conferences. All right, let's get into the video.
Morning, everyone can be seated.
Morning. Morning, Josh.
Coming in from one of my mystery entrances to keep everyone on their toes. All right, do we have our next grouping of jurors that's ready to come up?
Yes, sir.
Okay. Do the parties have anything to raise with the court before we bring in the next grouping?
Judge, just one thing. You offered yesterday that the courtroom is wired.
Correct.
We might have the ability to hear a tape of the proceedings.
As far as what was going on in the gallery, if you need to try to obtain it, yes. I mean, to the extent the camera is always running in this courtroom, whatever sound it's picking up, you can certainly request it.
Thank you, sir. Thank you.
State anything to address?
Judge, we would request that Your Honor read the burden of proof, what else? Presumption of innocence, and probably maybe right to remain silent. Those seem like things that were coming up in our individual voir dire.
I don't have a problem doing that. I was assuming it could hold until we got to group voir dire, but given some of the issues that were raised by the prospective jurors, I certainly believe that's proper. Does the defense wish to be heard as the reading of those instructions?
No, Your Honor, I defer to the court.
Very well. Presumption of innocence, burden of proof, and right to remain silent will be read as a part of the introduction that the new grouping of jurors will be given this morning, along with the statement of the case. One thing that I typically go through as well is the actual reading of the indictment or the information, but do you all prefer it just to be left at the statement of the case for now?
I would just say the statement of the case, and the only thing that I would add is that this is then going to be repeated for the jurors that didn't hear this yesterday.
The statement of the case?
Well, no, not the statement of the case. The presumption of innocence.
Correct.
Now,
before we begin the group of voir dire, believe me, I'm going to read it again just because it's as many times as they can get into their minds. The defendant is presumed innocent. The state has the burden of proof. He does not have to speak. The better off we'll be as far as getting through the group process.
I believe you, Your Honor.
All right, let's bring them in. Everyone can be seated. Good morning, ladies and gentlemen. I'm Stephen Everett, one of your circuit judges for the Felony Criminal Division here in Leon County. You have been summoned here today as prospective jurors in the case of the State of Florida versus Charles Adelson. This is case number 2016 CF 3036B. This is a criminal case. The state has charged Mr. Adelson with the crimes of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. You will notice at times during the jury selection process that I will be reading to you. It's not that I do not wish to have a free-flowing conversation with all of our prospective jurors, but rather any explanations that you're to receive concerning the law must be uniform and specific. Is the state ready to select a jury?
Yes, Your Honor.
Is the defense ready to proceed?
We are, Your Honor.
And for the record, I'm going to note that Mr. Adelson is present in the courtroom with his counsel. The first thing that I'm going to do this morning is go through the qualification process with you. I think you will find that the questions I'm about to ask will be fairly simple. This will also probably go a little bit quicker if I walk down to where you are, so that way I can see your responses and see if anyone has their hand raised. If all of our prospective jurors could please rise and raise your right hands. I'm going to administer the oath to you at this time. Do you solemnly swear or affirm that you will answer truthfully all questions asked of you as prospective jurors, so help you God? You may be seated. The series of questions that I'm about to go through with you are based on statutory provisions that would disqualify you from serving as a juror if you cannot answer in the affirmative. If your answer to any of the questions I'm about to pose to you would be no, please raise your hand. Are you at least 18 years of age? Are you a United States citizen? Are you a legal resident of Leon County? Do you possess a driver's license or identification card that has been issued by the Department of Highway Safety and Motor Vehicles, or have you executed an affidavit attesting to your eligibility to serve as a juror? Have you ever been convicted in any state or federal court of bribery, forgery, perjury, larceny, or any felony, and your civil rights are not restored to you? Are you at the present time under any prosecution for any crime in any state or federal court? That being said, no hands were raised for the record, and all the jurors are qualified to serve. The next thing I'm going to go through with you are bases on which you can be excused by law. Depending on the scenarios that I'm about to read to you, if you fall into any of these categories or believe that you may be excused based on the information I'm about to give you, please raise your hand as well. Is anyone here a full-time, sworn, federal, state, or local law enforcement officer or investigative personnel? Is anyone here an expecting mother or a parent that's responsible for the full-time care of a child that's under 6 years of age? Is anyone here 70 years or older? We will stick with you, ma'am, for a moment. Has anyone performed state jury service in the last year? Is anyone responsible for the full-time care of a person with a physical or mental incapacity who is incapable of caring for themselves, and you being here today would cause a hardship for that individual? Is anyone here a full-time student between the ages of 18 and 21 who is attending either a high school, a state university, a private post-secondary educational institution, a Florida college system institution, or a career center? For everyone that raised their hands, if you can form a line right here, and we will address you one by one. The attorneys can return with me to the bench. Here, this will give the instruction to the case. The first thing that we're going to do today is to discuss what you may know about this particular case. This case has received a fair amount of publicity, and there was also a related case that took place about a year ago. This process is going to be handled individually because you don't need to know what anyone else may know about this matter. However, before we start the questioning, I'm going to give you some very important instructions. Many of you have cell phones, computers, and other electronic devices. Even though you have not yet been selected as a juror, there are some rules that you must follow about using your cell phones, electronic devices, and computers from this point moving forward. You must not use your phones or devices to search the internet or to find out anything that is related to this case. Between now and when you have been discharged from jury duty, you must not provide or receive any information about your jury service to anyone, including your friends, co-workers, and family members. You may tell those who need to know where you are that you have been called for jury duty. If you are picked for the jury, you may tell people that you have been picked for a jury and how long the case may last. However, you must not give anyone any information about the case itself or the people that are involved in this case. You must also warn people not to try to say anything to you or write anything to you or about your jury service or the case. This includes face-to-face, phone, or computer communications. In this age of electronic communication, I want to stress that you must not use electronic devices or computers to talk about this case, including tweeting, texting, blogging, emailing, posting information on a website or chat room, or through any other means at all. Do not send or accept any messages, including emails or text messages, about your jury service. You must not disclose your thoughts about your jury service or ask for any advice on how to decide the case. Further, you must not read nor listen to any news accounts about this case until you have been excused. Avoid the newspaper and television broadcasts, particularly the local news stations. Also, avoid social media or any internet news websites. I will now read to you a statement of the case that has been agreed upon by the attorneys. On July 18th, 2014, FSU College of Law professor Dan Markel was shot while seated in his car. This happened in the driveway of Markel's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green colored Prius. Defendant and alleged conspirator in this murder was the former brother-in-law of Dan Markel and has entered a plea of not guilty. The statement of the case that has just been read to you is not evidence, and it is not to be considered as evidence or any proof of guilt. You are merely being informed of the accusations that the state has made against the defendant. I'm next going to give you some instructions concerning the presumption of innocence, the burden of proof, and the right to remain silent. During the questioning that will take place individually with the attorneys this morning, you may hear certain terminology such as burden of proof, presumption of innocence, and the right to remain silent. It is important that you understand these concepts as we move through the process. I will attempt to explain to you at this time the burden of proof, presumption of innocence, and the right to remain silent by reading the jury instructions that are applicable to each concept. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant may not take the witness stand cannot influence the jury in any manner whatsoever. Before we speak with you individually, I'm going to advise you concerning the questions that are going to be asked by the court in the room that will comprise the individual voir dire. These are basic questions, and if you are thinking about these questions when you are brought back, it will help us go through the process a lot more quickly. The first question will be, what do you know about this case? The second question, what sources have you obtained this knowledge from? Third question, based on what you know, do you have an opinion about Mr. Adelson's guilt or innocence? The fourth question, can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence that will be presented in the courtroom? Are you capable of being fair and impartial? And the last question, do you have any reason that you cannot serve on this jury for possibly up to 3 weeks? Again, it will save us all a great deal of time if you think about these questions and you are prepared to provide prompt answers when you are called back to discuss them with myself and the attorneys. The last question I'm going to address a little bit more. We expect this process to last through possibly Wednesday or Thursday of this week, and after the jury selection process is over, the trial will actually begin. In total, we expect that these proceedings may last, including, from today, but up to 3 weeks, possibly. We understand it's a burden for anyone to serve for that length of time. However, our system of justice cannot work unless we have good people that are willing to do their civic duty and to serve as jurors. Similar to people in military service, we do have to call on our citizens to make serious sacrifices. Jury duty is one of those times. You will probably never be called again to serve for a length of time, such as the 3 weeks. However, I understand for some of you, this may not be possible. To give you more information about what this trial is going to involve, you will not be sequestered if you are selected for the jury. You will go home at the end of the day and you will return the next. For the most part, we intend to work a regular business day, but on some occasions it may be necessary to work a little bit longer based on the witness schedule. I am going to do my best to adhere to a regular schedule, so please give it serious thought. If any of you would have a major problem, including a physical issue, that would prevent you from giving this case your full attention and serving as a juror for the time period that has already been identified. Please be patient with us this morning. We will be working as efficiently as we can. The bailiffs, the clerks, and court administration will be assisting you here in the courtroom. Please follow all instructions from the bailiffs and the clerks. Do not discuss this case while you're waiting or anywhere else until you have been excused. Also, do not listen to or read any media accounts on your phone or anywhere else until you have been excused. It is very important that everyone follows this instruction about not discussing this case while you are waiting. We do not want to have a mistrial, which would be to have to start this process entirely over because people are not following the instructions. Bailiffs, if you hear anyone discussing this case, please bring it to my attention immediately, and from there, I am going to address the issue in a prompt and appropriate way. If the attorneys can please go back to the jury room, we will get started.
Thanks, Kate.
Good morning, everyone. We are going to continue with the individual voir dire. However, I just wanted to let you know we are going to take a break for lunch at this point. You will need to return to the jury assembly room. That's where you started off this morning at 1:15. From there, an assistant clerk will bring you up and we will complete the process. The instruction that you've already received today not to discuss this case with anyone or look at any news reports or search out any information online. Again, I'm going to need everyone to respect that instruction that you've received. Please do not violate it. We do not want to cause any issues that would otherwise disrupt the process that we're in right now. Enjoy your lunch break. We will see you after.
I almost did. I almost did. I did. I almost did. Sorry. I apologize right now.
I don't care.
Good afternoon. Everyone can be seated. I was told by the clerks that we are missing one of our 50 from earlier this morning. We're just going to get started without them. Please bring in the jurors that we have to examine still. Everyone can be seated. Members of the panel, we are going to resume at this time with the individual voir dire. If the attorneys can return to the jury room and get set. Once again, for everyone who is remaining out here while you are waiting, please do not discuss the case with each other or anyone else. We will be with you as quickly as possible.
Guys, court is back in session.
Everyone can be seated. At this point, we are going to need the reserved chairs for
Oh, yeah.
the 21.
Thank you.
Is Ms. Cappleman back yet?
back in a second.
Okay.
I understand. Figure we'll sit all over the room. Keep figuring. Okay. Hey, listen. Grab your-
All right, while we're getting set for the group for dire, let's go ahead and address one issue that I've just thought of. The indictment has not been read yet to the prospective jurors. Did the state or defense wish for the court to read that now that we've reached this stage of the process?
Yes, Your Honor.
No objection, Your Honor.
Very well. As to the wording of the indictment, does the defense have any objection as to the wording within it?
No, Your Honor.
Then it will be read in full. Yes. You better up. We're reading up on this.
Your Honor, before the jury is brought in,
Yes, sir.
not going to mention the name. Would you, I know Your Honor's been very careful to do this so far. Would you just put even a heavier emphasis on the admonition not to post on social media? There's one prospective juror, juror number 19, who made a post today. I'm sorry, 119, who made a post today. It's a fairly innocuous post, taking what the kids call a selfie, at least my kids, and commenting about doing their civic duty. I've seen that slide downhill real quick when someone gets comfortable posting about jury service. So I want to get out to the court, and hopefully that's the worst of it.
You have it handy?
Yeah. Can you please show Georgia the post?
All right, we'll settle this and then they can be brought in. State, do you have anything to add concerning this?
No, Your Honor.
Right, I will instruct the prospective jurors as requested. Please bring them in.
Thank you, Your Honor. Didn't I know that one?
Pretty innocuous. I appreciate it.
Yeah, but it's just that some of those posts and they get carried away. It tells me that they're into
Right.
consuming shows on social media.
Yeah.
Hold on, Cheyenne.
I'm very excited about it.
She wants to be. You want to see what I wrote about her?
Nope, I trust you.
No, okay, I know you. I'm gonna show you anyway. Look. Abby seems like she wants on.
Thank you.
Thank you, Deputy. Take one, pass it down. Just need two more. Thank you, sir.
That's fine. We're going to go without him. If the clerk could read the numbers as to the combined panels of who will not be present this afternoon. Just the new number based on the combining of all three panels.
Seven, 14.
Yes.
We can agree on that.
What we'll do then is seat 22, 23, and 24 in their place. The attorneys get that. 7, 14, and 28 are who we discussed earlier. 22, 23, and 24 are going to be seated in their place.
I'm sorry, Your Honor. I'm slow. 7,
7, 14, and 28.
yes.
22, 23, and 24 are going to be seated in their places. Or at least for the 21 to be initially seated now, that would just be 22 and 23.
Got it. Thank you.
Bring them in.
22 is the one with the medical appointment.
Oh, yes. That's fine. We'll bring him in and release him now at this point.
So it'll just,
So it would really be 23 and 24 then, once 22 is released.
so 23 will go in seat 7 and 24 will go in seat 14.
Then in seat 7 will be Mr. Rogers 122, and seat 14 will be the unrelated. Do we have everyone?
Yes, sir.
Well, welcome back, prospective jurors. I believe some of you we have already visited with this morning as a part of the individual voir dire, and now the rest of the voir dire is going to be conducted here together in the courtroom. Voir dire is a French term meaning to speak the truth. When you were sworn in, either yesterday or today as prospective jurors, you were sworn in for that very purpose. First, I'm going to ask you some questions, and after I've finished, the attorneys are going to have their opportunity to ask you some questions as well. This is going to be the attorney's only opportunity to engage in direct conversation with you while the trial is happening. The purpose of this questioning is to assist the attorneys in determining if your verdict in this case would be unduly swayed or influenced by your personal experiences, any opinions that you currently hold, or any special knowledge or training that you may possess. The object of this process is to select jurors who will impartially try the issues of this case that's based on the evidence that will be presented in the courtroom without being influenced by any other factors. It is important that you be totally candid and truthful with us through this process. Please understand there will be no wrong or right answers to any of the questions that will be posed today. The correct answers are what you think and what you actually believe. The attorneys are not attempting to embarrass you in any way. If a question is asked that you feel uncomfortable answering in the open courtroom, you'll have an opportunity to answer that question during a private sidebar. Each party to this case has the right to excuse a certain number of jurors without giving me any reason. If you are excused by either party, do not feel offended or feel that your honesty or integrity is being questioned in some way. If you are not chosen for this case, it does not mean that you are not fair or impartial, or that you could never be fair or impartial, but rather it would mean that you are not suited for this particular case. It may be necessary during the jury selection and also during the trial for me to speak with the attorneys and the defendant about matters privately at the bench or with the jurors out of the courtroom. Please do not speculate about any bench conference when it takes place. The bench conferences should in no way affect your duty as a prospective juror in this matter. We have several bailiffs who will be working with us, and it is their job to enforce the court's orders, provide any security that is necessary, and also to have charge of the jury. That is, to assist you with any reasonable needs that you may have. If you have questions about your personal welfare apart from this case, you should direct those questions to the bailiffs. However, do not ask the bailiffs any questions about this case. A statement of the case has been previously provided to you before we began the individual voir dire. I am now going to read to you the material part of the indictment that has been filed against the defendant. The indictment is not evidence and is not to be considered as evidence or any proof of guilt. You must not be influenced by the fact that this indictment has been filed. It is merely a formal method by which the state makes an accusation against the defendant. Count 1. It is alleged that on the 18th day of July 2014, Katherine Magbanua and Charles Adelson in Leon County did unlawfully kill a human being, Daniel Markel, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markel, contrary to the Florida statutes. Count 2. It is alleged that beginning in 2013 and until October 11th of 2016, Katherine Magbanua and Charles Adelson in Leon County in the state of Florida did agree, conspire, combine, or confederate with each other or another person to commit first-degree murder, contrary to the Florida statutes. Count 3. It is alleged that beginning in 2013 and until July 18th of 2014, Katherine Magbanua and Charles Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Luis Rivera and or Sigfredo Garcia and or Katherine Magbanua, to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markel, contrary to the Florida statutes. I'm now going to ask you a series of questions in which I'm going to need you to respond to. For everyone in the gallery, so you understand the distinction that I'm drawing at this time, the initial jurors to be questioned this afternoon will be the 21 jurors to my immediate left. For whatever reason, if we're not able to select a jury out of this group, we will ask those of you who are sitting in the gallery right now to fill these seats. It will be very important that you pay attention to everything that is taking place, because if you are asked to fill a seat at that point, we are going to want to move along without any hesitation or delay. For the 21 jurors that are seated to my left, whenever I ask you a question, please raise your hand if you are responding in the affirmative. Has anyone previously served on a jury? Please raise your hand at this time if you have. Please leave your hands up. Ms. Walker, would you please tell us where and when you previously served on a jury?
Yes, I would think it was a federal case, and it wasn't this building, it was like a building across the street about 25 years ago.
Do you recall if it was a criminal or civil proceeding?
It was a criminal.
Do you recall the charge or the type of case?
Drugs, abuse drugs.
Without telling us what the verdict was, did the jury reach a verdict?
Yes.
Were you the foreperson of the jury?
No.
All right. Mr. Weaver, could you please tell us where and when you previously served on the jury? Oh, I'm sorry. Gosline.
Duval County, about 5 years ago.
Was it criminal or civil?
Criminal.
Do you recall the charge or type of case?
Yes, it was murder and drugs.
Without telling us what the verdict was, did the jury reach a verdict in the matter?
Yes.
Were you the foreperson of the jury?
No.
Thank you. Mr. Brown, where and when did you previously serve on a jury? You can lower your hand, sir.
It would have been sometime about 8 or 9 years ago, I believe, here in the county. If I remember correctly, it was on this floor at the corner.
Was it a criminal or civil proceeding?
As I recall, criminal,
Do you recall the charge or the type of case?
some sort of that.
Without telling us what the verdict was, did the jury reach a verdict?
We did.
And were you the foreperson of the jury? Mr. Brazos, please tell us where and when you previously served on a jury.
About 15 years and it was here.
Was it criminal or civil?
Criminal.
Do you recall the type of charge?
It was a robbery of breaking and entering a control store.
And without telling us the verdict, did the jury reach a verdict?
Yes.
Were you the foreperson?
Yes.
Mr. King, could you please tell us where and when you previously served on a jury?
So twice, Duval County. First time was 2016. Second time was 2017 to 2018.
Okay. And criminal or civil proceedings?
Both were criminal.
Do you recall the type of charges or the case?
The first one was sexual battery on an individual under 12. The second one was armed robbery.
Without telling us the verdict, did the jury reach a verdict each time?
Yes, sir, both times.
Were you the foreperson of either jury?
I was the foreperson of the first jury.
Could you please tell us where and when you previously served on the jury? Was it criminal or civil, if you can recall? Do you recall the type of case it was? Without telling us the verdict, did the jury reach a verdict? Were you the foreperson? Did I miss anyone who's previously served as a juror? For those of you who have previously not been called to jury duty, there is no experience requirement to serve on a jury. You do not need to know any law or procedure. All of that will be explained to you. What you will need to do is to be able to listen carefully, apply and follow the instructions that you will be given concerning the law, and also use your common sense in deciding any issues of fact if you are selected as a juror. The state of Florida, in this case, will be represented by Assistant State Attorneys Georgia Cappleman and Sarah Dugan. And the defendant is going to be represented by Mr. Daniel Rauschbaum. Mr. Rauschbaum, could you please introduce your co-counsel and your client to the prospective jurors?
Yes, Your Honor. Good afternoon. My name is Dan Rauschbaum. With me at counsel table is Kate Myers and Joshua Dubin. And this is Charlie Adelson. Good afternoon.
Thank you. Are any of the prospective jurors related by blood or marriage to any of the attorneys? Please raise your hand. Do any of you know any of the attorneys that have just been introduced? Please raise your hand. Mr. Brown?
You probably wouldn't remember it, but Calvin's son played baseball with one of my boys. That's how we know each other.
Right. Would your knowledge or this relationship to Ms. Cappleman cause you to give her greater or less weight to any evidence that will be presented by her? Are any of you related by blood or marriage to the defendant? Do any of you know the defendant? Ms. Cappleman, if you please could read through the names of the witnesses who may be called by the state during the trial.
Yes, Your Honor. May it please the court.
Please pay careful attention to the names that will be read by Ms. Cappleman. You may proceed.
Thank you. I've included names of people whose names may come up during the trial as well as potential witnesses in the trial. And those are as follows. Donna Adelson, Harvey Adelson, Rob Adelson, Wendy Adelson, Amy Adler, Sergeant Sherry Bennett with the Tallahassee Police Department, Dr. Shelby Blank, Officer Bill Brannon, Tallahassee Police Department, Special Agent Louis Greg Bronstein, Special Agent Justin Karsten, both of those officers are with the FBI, Dr. Anthony Clark, Sergeant Chris Corbett with the Tallahassee Police Department, Brock Dietz is with the Fire Marshal's Office, Investigator Michael Dillmore is with Tallahassee Police Department, Ryan Fitzpatrick, Sigfredo Garcia, Jim Geiger, Detective Jonathan Grossman is with, I think, Miami Police Department. He's a law enforcement agent in South Florida. Mary Hull. Craig Isom is retired from the Tallahassee Police Department. Oscar Jimenez is retired from the FBI. Erica Johnson. Special Agent Brian Kendall with the FBI. Forensic Specialist William Cornegie. I believe he's retired as well from Tallahassee Police Department. Clariza Labredo. Jeffrey Lacasse. Katherine Magbanua. Joanne Maltese is retired from the Tallahassee Police Department. Keith McElveen. Ramsey Neighbor. Investigator Jason Newland is with the State Attorney's Office. Waldo Nunez. Shadrick Nobles. Jerome Obed, he's a doctor, a dermatologist in South Florida. Danny Beth Ritchie, she is with the Florida Department of Law Enforcement. Luis Rivera. Jessica Rodriguez. Marcia Rodriguez. Marcia Rodriguez is with the Tallahassee Police Department, or was at the time. Carrie Rosanna is with the Florida Department of Law Enforcement. Special Agent Pat Sanford with the FBI. Stuart Schlazer. David Sims is retired from the Tallahassee Police Department. Robert Schwartz. June Umchinda. Yendra Velasquez Mascaro. Stephen Webster. And Sean Yao is with the Tallahassee Police Department.
Mr. Rauschbaum, are there any witnesses who may be called by the defense that are not on the list that was just read by counsel for the state?
Yes, Your Honor, there are a couple.
If you could read those names.
Kristen Adamson, Gary Cohen.
Do any of you know any of the witnesses who have just been identified by either counsel for the state or the defense? Please raise your hands if you know any of the witnesses. Yes, sir. If you could identify which witness.
I know Dr. Sister of the Bank that you made.
In what capacity have you known the doctor?
I am a take that with them from time to time doing surgery.
Would your acquaintance with the doctor prevent you from considering her testimony impartially?
No.
Would your relationship or knowledge of the doctor cause you to give greater weight or less weight to her testimony?
No.
Right. I'm now going to ask each juror a series of questions. Please respond fully to these questions. This is to provide the parties with some general information from you, and the attorneys may follow up with some more specific questions when they have their opportunity to inquire. The benefit of being number one. Please tell us your full name. What is your occupation, or what type of work are you involved with?
In Health and Human Services, we certify, I work for the Florida Certification Board, and we certify protective investigators and other health and human services for them.
And that's related to the Department of Children and Families?
Yes, sir.
Okay. What is your marital status? Do you have any children?
I do.
All right. How old are they, and what are their genders? What do they do for their occupation or work? How long have you lived in Leon County?
I've been here since in here for over 20 years.
Do you have any close friends or neighbors or relatives that work in law enforcement? Have you or any of your close friends or relatives ever been charged with any criminal offenses? And to clarify, this would include also criminal traffic, similar to driving with a bad license, DUI, but not speeding or any traffic infractions. Have you or any close friends or relatives ever been a victim of a crime? All right. Part of the issue of turning a courtroom into a live wire. We'll move on from here. During the attorney's questioning, you may hear certain terminology such as burden of proof, presumption of innocence, and the right to remain silent. It is very important that you understand these concepts. I will attempt to explain to you each one, the burden of proof, the presumption of innocence, and the right to remain silent by reading the jury instructions that are applicable to each concept. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his or her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant may not take the witness stand cannot influence the jury in any manner whatsoever. During the qualification period, I previously gave everyone an instruction concerning not discussing this case, which would extend to your social media. Once again, I'm going to give you this instruction to remind you that it is very important in selecting a jury. You must not discuss the case with each other, your friends and family, or anyone else, or through using social media or any other device. The attorneys now are going to have their opportunity to ask you their questions. What they say now or at any other time during this trial is not to be accepted by you as evidence or any instruction on the law itself. They are simply going to be asking you their questions. Please do not infer anything or read anything into the questions they are about to ask. Before I turn it over to the attorneys, I'm going to remind you to please answer their questions honestly and also volunteer any information that you believe is important. Is counsel for the state ready to inquire?
Yes, Your Honor. May I please report?
You may proceed.
A few follow-up questions, and then I want to talk about some big concepts that I think may come up. This is not the trial, so we'll be discussing some issues that we think could arise in the trial and try to get your idea of what you think about these things as you walk in here. You're not required to know anything. It's better if you don't know anything about the law, but we just kind of want to get an idea about your experiences and your thoughts about some of the things that might come up. First of all, does anybody on the panel know each other? Anybody know each other? Okay. For my shy guys, and I guess I would include really bored guys, sleep-deprived people, angry people, participation is very much encouraged, and that will help a lot, even if you hate me and you're bored and you're miserable. Just do your best to get us through, and that'll be super helpful. There's no wrong answers. We talk about biases, implicit and explicit, and out in the real world, those things typically imply something bad. If you're biased or prejudiced, that's bad. But really what we're looking for is just experiences that might have you kind of feeling one way or another, not necessarily in a bad way. So we're just trying to get your feelings, your experiences, things that have shaped you. So please don't be embarrassed to let us know. If I do ask you something that is particularly personal or embarrassing, please ask, and there might be some very limited version of privacy that we can provide where you're outside the presence of the other jurors. So this is, you've heard the charges, you guys pretty much know this is a pretty serious matter. Does anybody right off the bat hearing the charges think, like, this isn't for me? Something about me makes me not right for this. Okay. I want to talk a little bit about you guys as far as your professional lives and whether anybody's in a leadership role. Let's start with the first row. Anybody consider themselves a leader on the first row? Consider yourself a leader. Is that because of work or something else? Just your personality or something else? Because of work. Do you supervise people at work? Okay. How many folks do you supervise? Okay. All right, thank you. Anybody else on the first row? Yes, sir. Mr. Gosline. Wow, it's a lot of cats to herd. What you don't have to tell us, but if you want to plug the restaurants, you can. Okay, he'll pass. Second row, leaders. Okay, yeah, Ms. Rubino. Rubino, thank you for correcting me. Go ahead.
I lead a small team of scientists.
Okay. How many folks on your team? 18. Not too small. Okay. Somebody else? Yes, ma'am, Ms. Williams.
Yeah, I'm a payroll manager. I manage.
Okay. All right. Anybody else in the back row? Oh, sorry, I missed you. Ms. Bell. Okay. And that's at the assisted living facility? Okay. Anybody else on the center there? Okay, back row. Back row leadership. Yes, Ms. Parker.
Well, I've been a property manager for 30 years, and I generally had a staff average of about 10.
Okay. How long ago did you retire?
When I was 62.
Oh, congratulations. Anybody else in the back row? Yes, sir. Mr. Fisher.
Lifeguard instructor for a long time, so I know a lot of people.
Where did you do that?
Various places, Red Cross, YMCA, Disney World.
Okay. All right. For my folks that didn't raise your hand, well, anybody have anything that's like serving on the, oh, yes, sir. Mr. King.
I held a director level position up until 2017.
Okay. How many folks did you supervise in that capacity?
25.
Anybody have anything where you served as like the president of a board or in a leadership role in some kind of something other than work? Mr. King.
I'm the president of my HOA.
Okay. Perfect example. Got to be a leader to deal with those cats. Okay. Yes, ma'am, Ms. Bell. Okay.
Nonprofit organization.
Okay. Anybody else?
Director of an improv troupe.
Improv troupe. We can tell. That's a good fit. Okay. Thank you, Mr. Weaver.
Board member,
All right. Cool. Anybody else? Okay. Thank you. For my folks that didn't raise your hand necessarily for leadership, would you consider yourself, by show of hands, to be an independent thinker? Let's do first row first. If you didn't already raise your hand for leadership. Independent thinker, like an especially independent thinker. Okay? All right, Mr. Triplett, what's that based on?
I guess maybe my 15 years in law enforcement where I was routinely on patrol alone by myself, having to make decisions on do I write a ticket, do I write a warning,
Yeah.
things like that.
Mm-hmm. Makes sense. All right, Mr. Brown? Yes, sir.
In my job, I deal mostly with that. I
Mm-hmm.
don't care what the person telling me, what the data is.
You're just the facts guy. Okay. Seems like a good guy for a jury. All right. Anybody else? Independent thinker? Mr. Weaver? It's all between the ears, right? Yeah, okay. Got to read their mind. It's like, you know, that scene with the clearly I can't drink the wine in front of you. You don't? You've never watched Princess Bride? That definitely has to happen. It's very relatable to your profession, I think. All right, second row. Independent thinkers. We already know Mr. Rubino is.
Well,
You're a teacher.
Right, I was going to say, I mean, I'm a leader of a bunch of little minds, but I do
It's
have
hard.
I do have a boss that leads me too.
Yes, okay. I guess what's the difference between an independent thinker and a leader? Is there a difference? I think it can be one and the same. Don't necessarily have to manage people to be a leader.
Right.
Okay. Anybody else on the second row have something? I mean, Miss Brinkley, I can't believe you haven't raised your hand. You just seem like just got leader written all over you. Do you consider yourself to be an independent thinker?
Well,
Or do you go with the flow? I mean, maybe you do go with the flow.
you know, I deal with a lot of patients each day.
Mm-hmm.
I have to communicate with family members over the phone.
You're more the caretaker.
Yes.
A firm, tough love caretaker.
Well, you know, I have to explain different situations to the family members. Sometimes they don't want to hear the truth, but I have to tell them what it is. And this is what it is. And I don't apologize for that because sometimes they need to hear the truth. And so that is what I have.
All right, thank you for that. Back row, independent thinkers that didn't already tell me about your leadership stuff. Okay, Ms. Spates.
I have been doing my job for 34 years, and I do it well without supervision.
So you are the pinnacle of independent.
Yeah. I also cater and decorate. So,
Okay. So you're running sort of a side hustle with catering? Okay, cool.
Okay.
Yes, ma'am. Back to Ms. Brinkley.
And I also take on other jobs at, Big Bend Hospice as well. I'm a nursing assistant and an administrative service assistant. I travel from different counties taking care of patients.
Is that volunteer stuff or side hustle stuff?
No. This is with the company.
Oh, as part of your job. Okay. All right. Anybody I missed on the back row or anybody anywhere that wants to tell me about independent thinking? Mr. Fry.
A lot of the work I do is independent. I specialize.
Mm-hmm.
No one else knows what I do in the company, including the manager.
Yeah, all I got was specialist, so that lets you know how great I did on what you said. What did you say you do?
The clients I bill are very specialized in the way they operate.
Right, but what's your job title?
Billing specialist.
Billing. Is that what you said? Okay, I missed that. Yeah, I was going to tell you I missed that. Okay, so a lot of very detail-oriented work that you have to be independently pursuing without supervision. Okay. Anybody else that I missed on that? Okay, anybody else with a side hustle that we don't know about? Anybody else that commits a lot of time to an organization, charitable organization, or something like that I ought to know about? Mr. Gosline. Baseball coach? Oh, you're going to have to get an autograph. Okay. Anybody else? Yes. Mr. Fisher.
I play with Lucasfilm, Disney, Star Wars stuff.
Okay.
We dress up as bad guys and good reasons.
That sounds fun. Like at schools and stuff like that?
Hospitals, charitable events. We go to all the conventions to raise money for things like that.
But only as bad guys?
Yeah. Bad guys doing good, I think is the whole thing.
That's cute. I like it. Okay. Anybody else? Something like that. Side hustles. All right. Okay. Anybody have any legal training? You do not need it. Just want to know if you have it. Okay. Anybody have any military service? Yes, sir. Mr. King.
4 years in the Air Force, from 6 to 90.
Okay. All right. Mr. Triplett?
4 years in the Air Force, 78 to 82.
All right. Anybody else? Thank you for your service. Anybody own a business that hasn't told us or owned a business previously? We know about Mr. Gosselin. Seemed like there was
Yeah, I'm currently self-employed doing IT.
IT. Okay. Anybody else? Mr. Brown? You and who? Okay. Okay. Anybody else? Small business owner, Mr. Fisher?
Your previous question, it's not legal work, but I do read the statutes a lot for work.
Mm-hmm. Okay, sure. Makes sense. Thank you. Yes, ma'am, Ms. Parker.
Well, my husband actually is, I'm a co-owner with the barbershop.
Okay.
He's the barber. So.
Barbershop. Yes, ma'am. Got it. Anybody else? Yes.
Following up on what he was saying, if that counts in my previous job, I worked for the Florida Department of Health, and we regularly read and analyzed prospective bills and wrote up what impacts those might have for the department.
Okay. Anything else? Yes, sir. Mr. Brazos. Auto shop. Okay. Thank you. Yes, sir. Mr. Fry.
Again, following up on the previous question, I was really special for a law firm.
Okay. Worked for a law firm.
They're looking for
Okay.
foreclosures and bankruptcy.
Thank you. Anybody else? Oh, you guys are doing so good at the talking. Keep it up. Okay. Anybody that had prior jury service experience have, absent this experience, had a bad experience with jury service? Not this one. We know how this one was. Anybody? Bad experience. Okay. Okay, so you've heard about the burden of proof, and the burden of proof is a high burden, right? It's the highest burden in the land, and that's because it's a criminal case, right? And the burden is beyond a reasonable doubt. That's a very high burden. It's my burden and mine alone. Well, Ms. Dugan's going to share it with me, but the state has the burden, right? That's how things work in our country. State proves the case. The defendant is innocent until proven guilty. Everyone good with that? Okay. This is a very high burden, but it is not impossible. Okay? We've got a system that's designed to protect the innocent, but also not make it impossible to convict guilty people. Knowing that, does anybody still feel like, in my heart, I understand what you're saying intellectually, but I require 100% mathematical certainty before I can render a guilty verdict on a serious case like this one? Anybody feel like that? First row. Ms. Walker, you just hold me to my burden and nothing more? Not going to make it impossible, are you? Okay, what about, I worry about Ms. Rubino, because you're a scientist, right? Everything has to add up and be right and perfect. Should I be worried about that with you? Would you hold me to a higher burden?
No, the thing with science is that you take the data that's available to you and you make the best decision with it. You
Okay.
don't need it to be perfect.
Okay. All right. Ms. Strawn, I'm sorry. Yes, no.
Rubino?
I can't do it. I can't do it. It's because I have a friend named Rabinus, so I'm just making you
That's a great name.
I can't seem to do it right. I'm going to write Bino.
Think Ruby and no.
I'm just going to, I don't know. Has anyone ever waited tables? Show of hands. You know how once you screw up a table, it's just everything goes bad for the whole night? You're that. Okay, don't hold it against me. I'm really sorry. I am trying to do well. Ms. Strawn, you're an accountant, so things need to add up. Things need to be right. The bottom line needs to be perfect. So if you're chosen and you hear days of testimony and you hear all the law that the judge gives you and you get all these pieces of evidence and you go back into the jury room to deliberate, you will have questions that are unanswered. And you'll think, what about this? What about that? That's going to happen. Your job as a juror will be to decide, is this question important? Is it material? Does it give rise to reasonable doubt? Because it won't add up, right? It never will. We're just going to give you the evidence that's left behind after someone commits a crime. And you decide as a juror, is it sufficient? Meaning, was it proven beyond a reasonable doubt that a crime was committed? And was it proven beyond a reasonable doubt that this defendant is the person or one of the persons that committed the crime? Can you do that? Can you hold me to my burden, but no more? Anybody feel like they would struggle with that? Yes, sir. Mr. Gosling. And many of you said when we were doing the individual voir dire, I'm open to hearing both sides. And like when you're navigating a situation with your kids or the boys on the baseball team, it's like you want to hear both sides, right? What do you have to tell me and what do you have to tell me? But that's not how it works in a courtroom, right? Because it's my burden. I have to prove the case as the state bringing the charges, and the defense does not have to do anything. So there's no sides. I mean, they may choose to do something, but it's not their burden. Does that make sense? So you kind of have to shift your thinking a little bit from, I want to hear both sides, to the state either meets their burden or they don't. And it won't totally add up all the time as far as, like, was the robber's hat green or red? One witness says green, one witness says red. Maybe that's a very important fact in the case, and you can't decide a verdict of guilt because there's a discrepancy in the hat color, or maybe it doesn't amount to a hill of beans whether it was green or red. Does that make sense? Do you think you can make the distinction between an insignificant inconsistency or an insignificant unanswered question and something that is significant and material to your deliberation? Well, it sounds like you're telling me, like, I'm a guy that wants everything to add up. Yeah. And this is a heavy thing we're asking you to do, right? Convict. Very serious charge. Are you thinking or concerned that maybe you would hold me to a burden higher than what I've described as my burden? You are. Okay. Anybody else fall into that camp? Okay, tell me about it. Mm-hmm. What you do is so much cooler than what any of us do. Like, you can talk about it as much as you want. Yeah. Mm-hmm.
Mentally impacts me quite a bit in my profession. It's something that I'm always kind of using professionally.
So because you demand that of yourself or you are striving for that yourself, it would be hard for you to come hear a messy, imperfect criminal case and make a decision? Mm-hmm. Perfection, like grind all day until it's done. Yeah. Well, I have a kid that's a little bit like that. Mr. Brown's met him. Okay. Anybody else have anything to say on that topic? What about who's hiding? Where are my shy guys? Mr. James!
I'd like to tell you something.
Okay. Okay.
As a tester, a lot of things you say sort of correlates to some of the things I have to deal with. Where it's like, we could try all these different things and all these what-if scenarios.
Mm-hmm.
At the end of the day, we have to decide, what's actually important for the current release that we're working on, and what's relevant, what's going to affect customers at the end of the day. And so I think that sort of goes into what you were saying about there could be a million what-if scenarios, but it should be beyond reasonable doubt.
Yeah, and I don't want to diminish the burden. It's very high. And the judge is going to read you instructions on it. He already has a little bit, but I just want to make sure I don't have people that are going to make it impossible, basically. There are some people that cannot convict someone of murder. Just can't, right? And I need to know if you fall into that category. It's hard to know because you've never done it. But if you can kind of, search your soul and let me know if you're one of those people, if you think you would really struggle with that. Even if the case was proven beyond a reasonable doubt, I feel like I can't do it for whatever reason. Anybody feel like that? Okay.
A little bit impacted. I wouldn't say full match, but I always think
Mm-hmm. Mm-hmm. Sure. Okay. Okay. Does it make you feel any better for me to tell you that we are not asking you to judge the person at all? We're asking you to judge the facts. The jury's the judge of the facts. So good person, bad person, doesn't matter. Was the crime committed? Is this the person that committed the crime? Does that help? Okay. For sentencing, that might be something that would weigh on you. Oh, what's the sentence going to be? That's not something you'll have to decide at all as a juror. It's just the facts. The judge handles the sentence. Everyone understand that? Anybody feel like that would be weighing on them? Yes.
I used to feel sorry for a lot of people, like, and when I become a mother and raising a teenager girl, I used to say, oh, she my baby, she this, she that. But once she got older and she started lying, one lie after another lie, and I would, say, Taylor, why? And then I began to realize, okay, I'm not going to say anything anymore. I'm just going to let her tell me what she has to tell me, and then I'm going to tell her, look, I'm taking my car away from you. You don't deserve anything from me because you're lying. When she say, no, I didn't do this. Yes, you did.
Yeah.
And so throughout the years, and even dealing with people and, with my patients and all now, I can't feel sorry for people. And if you did something wrong, then there are consequences that you have to pay.
Action and consequence.
Yes.
That's the business we're in here.
I have had to learn over the years, I cannot act out on my emotions or feel sorry. I cannot.
Okay, so no sympathy at all for any human beings.
Not anymore.
Got
Not
it.
with me, I used to, but not anymore.
Does anybody feel like they do have sympathy and are a sympathetic person to the extent that it could impact your deliberations in the case? How about you, Mr. Conyers? Do you feel like you're a particularly sympathetic person?
I say no. I say in between. No.
Okay. Do you feel confident that you can do the job we're asking you to do if the case is proven, or if it's not, you know what you need to do? Okay. Ms. Gardner, you think you can do that?
Definitely, yeah.
Anybody feel like they would struggle? Yes, ma'am. Ms. Williams.
I know we've had a lot of comments in between your
Where you were trying to talk?
Everything adding up, and I just wanted to, first off, yes, I am a sympathetic person, but what I wanted to say is I'm extremely detailed.
Mm-hmm.
I can't stand it if my checkbook is out.
Right.
I want to know if it's red or if it's green. So
Right.
there as far as things not adding up, am I going to be so caught up in the
Mm-hmm. Do you have confidence in your own ability to recognize when you're doing that and make a decision like, oh, hey, am I getting bogged down in something that doesn't matter? And then let it go? Or are you going to dig in and be like, I got to know if it's a red hat?
I'm not above being
Okay. Anybody else work as part of a team, first row, or worked as part of a team for my retired guys? Okay. Obviously. Baseball team. Second row. Yes, sir, you're on a team. Okay. Yes. Rubino. Back row. Team. Anybody? You guys work as part of a team? Okay. Anybody feel like they're so independent or so used to working independently that you're gonna like not be able to listen to your fellow jurors? Everybody feel like they can listen and take in information, because we want, the verdict has to be what? Unanimous. So it's got to be the verdict of each individual juror as well as the jury as a whole. We want jurors that are going to stick to their guns back there and not return a verdict that's not your verdict. But also, you know, you're going to listen. And you may have your mind changed on some things. Listen, take in information, and ultimately, it's your decision. Does that make sense? We'll give, we'll take. We'll give, we'll take. Okay. For my folks that have had themselves or a friend or family member involved with a criminal case, anything about that case that you think I ought to know, you have strong feelings about it, you feel that person was not treated fairly, anything like that? Not treated fairly. Okay. Anybody with a divorce? Ms. Daigle, you've got a 3-year divorce going. Anything about that that you think might impact your deliberations if the case involves a messy divorce?
No, I haven't had any progress in 3 years, so what do you think about?
Okay. Anybody had interaction with the court system, a divorce or something else that has impacted you and given you strong feelings about the justice system, the court system? Okay. Anybody else had a super messy divorce?
I had a divorce in 2000. Like my person that I left here was 2-3 years.
2-3 years. Okay. Anything about that that you think would impact your deliberations if the case involved a divorce?
No, because it was him.
Because what?
No, because it was my ex-husband that made it legal.
Because it was his fault. Okay.
Starting mine during COVID didn't help either. So that was part of the...
Sure. Yeah, we kind of all ground to a halt during COVID here in the court system. Okay. For my folks that I have lied to and ruined your life, and I'm talking to you, Mr. Brazos, I told you you would make your doctor's appointment today, and you did not, and I want you to know I really feel bad about that. I'm pretty sure it's not my fault, but I still feel really bad about it, and I think all of us intended for you to get there, but it didn't happen. All right, so what are we going to do about that? If you're selected, we're going into a 2 to 3 week ordeal here. Are you going to be able to? It's going to be okay. Okay. Mr. Brown, we ruined your life today because you didn't go to a seminar. How's that working out for me? Great. All right. Anybody particularly mad about being here that is... Yes, you are welcome.
And what a good work, Bob.
Thank you for saving me. All right, we talked about my job. I put on the evidence. I have the burden. If you were asked to render a verdict right now, it would be not guilty because you've heard no evidence at all. Your job will be to listen to the facts and to be the judge of the facts. The judge up there is the judge of the law, so he's going to give you all the law you need. He's going to be the referee of the trial, and he's going to handle sentencing if the defendant's convicted of anything. Anybody, for any reason that you have not discussed with me, feel like they wouldn't be good for this case? Religious, philosophical, moral? Yes, sir. Mr. Weaver. Mm-hmm. It's a big ask right now.
I apologize for my mannerisms and the way I'm acting, but I'm placed mentally,
Exhausted.
yeah.
Okay.
I'll have to use
Okay, gotcha. Okay, anybody suffer from any hearing loss? Hearing loss. Okay, you're told. You're told you can't hear. You think you hear fine. You think everybody mumbles. Okay, so we got one, possibly two. Okay, there are audio recordings that I expect to be introduced in this case, and I've provided some headphones that hopefully will make it you able to hear. But I do want you to tell me if you think, like, have you heard me fine so far while we've been in here? Okay. Anybody else that I didn't get with hearing loss? Anybody else that I didn't? All right, I want to talk for a moment about law enforcement. Those of you that have yourself or friends or family members that were in law enforcement, the reason why we ask about this is because, as you heard, there's quite a few law enforcement officers on the witness list that could potentially be witnesses in the case. And we want to try to get jurors that don't automatically believe or automatically disbelieve law enforcement officers just because they're wearing a uniform. So they can be mistaken, they can be wrong, they can lie, or they can have special training and education and experience and credentials that make them more observant or more capable of, more credible on certain types of issues. But you need to hear what that is before you decide. It's not just the uniform. Does that make sense? So we want them to kind of start on an even playing field, and once they tell you about their training and education and credentials, you can start giving them more credibility. Okay? Can everyone follow that instruction? Anybody not follow that instruction? Anybody feel like law enforcement starts out ahead, credibility-wise? Yes, sir, Mr. Gosling. Gosling.
We talked to police officer for 26 years. He works for the Police Office now.
Okay. Automatically. Okay. Can't be wrong. Okay. It's their job to be right. It's my job to be right too, right? It's everybody's job to be right. Anybody else feel like that? Like law enforcement just starts out a step ahead? Automatically? Sure.
Not close to them, a couple that were in Jackson County, and they were in the last year in court for one of their fellow officers that was planning drugs and didn't do to show up at. So we go either way.
Sure.
They went to court with uniform.
Sure. Yeah, so you agree. You don't know what you're going to get. So you get it and observe it and weigh it as you would any other witness. Good and bad and all the things. Okay, everyone else agree with that? What are y'all's thoughts about a case that involves more than one person doing a crime? Can more than one person be guilty of the same murder, Mr. Fry? How? Meaning like they're both swinging the bat or both shooting? They could both plan it. Okay, so if the court reporter and I, every jury selection, we do crimes together, don't we? If we go to do a liquor store robbery, we both intend for a liquor store robbery to occur. I take her there. She goes in. She robs the liquor store. Somehow in the process, she kills the clerk. Am I on the hook for that?
You with her?
I went, I helped, I drove her there. So I drove her there to do a robbery. We agreed. This is what we're going to do. I'm going to take you there. You're going to go in. You're going to rob. And I probably should have told you a murder in the course of a robbery is a murder. Okay? So she goes in. She does a murder in the course of a robbery that I planned with her. And then I drive her away. Maybe I even get rid of the murder weapon. Can I be charged the same as her? I can? What do you think, Mr.? Listen to them answering your question.
Oh, I'm sorry.
I'm just teasing you. I love it. Thank you.
It's wrong.
Mr. Fry.
Be accomplice, right?
Say that again? Could be an accomplice, an accessory. Okay. Okay.
Because if proven guilty, you both should be charged of the crime that
Okay.
not of the same crime, because you all did two different acts.
We did do different roles in the same crime.
No,
Well, the
one of
way
you murdered someone.
Okay, right?
But the way I see it,
Mr. Dubin, do you have an objection?
Very reluctantly. I'm just a little bit concerned about where this is going in terms of what the law is. All for the hypothetical, I understand it, but I think that the law should come from the court and Your Honor, and we're talking about accomplice and the felony murder rule, even though it's not being called the felony murder rule, so I would just ask for the court to, at the appropriate time, if it starts to weave into the area of the law, I don't want the jurors to be under any misimpression about where the law comes from.
I don't think that will take place, but as it relates to the state being able to test its theory of the case in the same way the defense would as well, I think she's entitled, but Ms. Cappleman will allow you to respond.
I'm not intending to go into the law. I'm just going to ask their thoughts about legal concepts such as principal theory, accomplice, all those types of things are appropriate, I think.
Response.
As long as I'm given the same latitude, then I have no objection. I'll withdraw it.
I cannot prevent you from testing your theory of the case. That would be reversible error. Same for the state. We're going to continue.
Thank you. Sorry for the interruption.
All right, so where were we? Ms. Brinkley.
okay, well, the way I see it, if two people gone out and one murdered and the other one did, look, they both was together, they talked about it, they plotted together, and they both deserve to be punished for that. And I think that just because the person that got away did not murder the clerk or whatever, you was there.
Okay, in for a penny, in for a pound.
Can I ask a question about that?
Yes.
What you're asking is a legal concept.
It is.
The way we're answering is it right or wrong? And so my
The
question
judge
to you would be, what is the statute about what the expectations would be?
The judge is going to give you all the law that you need. I just want to get your ideas. So you don't know the answer. Is it, can we both be charged the same or not? You don't know. I'm going to find out your thoughts about it, what it should be, what if it's this way, would you disagree with it? So that's kind of where I'm going. I'm just feeling you out.
Complicit in the same crime.
What do you think? Should we be complicit? Okay.
Well, you said that you didn't plan for the murder to happen, right?
Right. Plan for an armed robbery.
So if she goes in, you're in the car, you're not expecting her to see
Mm-hmm. So she
You
could.
don't know. How do you don't know?
That's how
You
she's
don't
explaining it.
know.
That's how she explained it.
But theoretically, we can be taking the risk because
you have made a choice to do a risky behavior that is an armed robbery, it would be conceivable that one of those alternatives would be the murder or the injury of somebody. So you're,
Especially if you help get rid of the murder weapon.
All right, this is amazing. Thank you. You were killing the court reporter there, so please try to go one at a time.
I'm sorry.
Okay, yes. Thank you, Ms. Rubino. You could have basically written the law, but as I mentioned, the judge will give you the law. So if we can be charged the same, who disagrees with that? Seems like Ms. Spates thought that would be wrong. Why would that be wrong for us to be both charged with first-degree murder?
I would have to be, it would have to be proven to me that when you all initiated that you all would do the crime, that you all talked about one person committing a murder.
Okay.
Because it might have been you all talked about just doing an armed robbery.
Okay, so it makes a difference to you if I knew it was going to be a murder.
Exactly.
If I knew it was going to be a murder, is it right? Even though I didn't go in. I didn't even go in.
Yes.
Okay.
Because you knew it was, so it should be some form of attempted or accessory or something.
Okay, so now we've changed the facts. Now I knew it was going to be a murder in the liquor store. Does that matter? Should we be charged the same? I didn't even go in there, y'all.
Or at least you conspired.
I conspired, okay. What's the difference between conspiring and committing the actual murder? Getting it done, right?
Pulling the trigger.
Okay.
Or harming the person.
So can only the person that pulled the trigger be guilty of the murder?
I didn't say that. You said what differentiates the conspirator from the actual murderer. The actual murderer harms the person.
Yeah, so getting the completion of the act. Right. Okay, we can agree on that. Conspiring.
But that doesn't mean that somebody else who helped to conspire or plan said murder can't be charged with that murder.
Okay. Does anybody disagree with that and think someone who planned or conspired to commit a murder and then the murder is committed, not by them, can be charged with the completed act of the murder? Anybody disagree with that law? What about you, Ms. Strawn? You've been quiet.
Go either way. I mean, I feel like the person that actually had the weapon and caused the murder is the murderer.
Okay.
You're an accomplice. I don't know how the law works in regards to what you would be charged with exactly. But
Sure.
legally, you should be charged with something.
Something, okay. And if the law is that we should both be charged with murder if I wanted it done and I did something to help, can you follow that law? Even if you disagree with it, would you follow it?
If I disagree with it?
Yes, ma'am. So we got the one that pulled the trigger and the other one that conspired and planned and drove and got rid of the murder weapon.
I would be okay with her getting within the car because you planned it together, you conspired together, you know. It's just a tough one for me.
Okay, let's assume that you disagree with the law. Would you be able to follow it on that issue?
You can. Whether I agree with it or not.
Okay, Ms. Bell, do you think you could do that too? Huh?
I would have to follow it.
You would. Okay, thank you. Mr. Conyers, would you be able to do that?
Yes.
Do you agree with that we should be charged the same, or do you think we should be charged different? This is the one where we both wanted the murder. And I took her there and she went in and did the murder. Should we be charged the same, first degree murder, or with something, should I get something a little different?
Yeah, I feel the one that pulled the trigger should be charged with murder, whatever, and then the one that drove the car should be charged with a lesser crime.
Something less.
Even though she was there.
And if the law was that we were both guilty, equally guilty of first-degree murder, and that was proven to you, and you disagreed with the law, would you still be able to find me guilty?
If you put the ticket?
No, I'm the driver. You don't think you could? Okay.
Like I say, there's two different crimes at the same scene. You put the trigger, but you go to the car.
Two different actions.
At the same thing.
One crime.
One killed, and she drove the car.
Yes, sir.
So, if we tell with murder, she could be charged with either whatever they call it, first-degree murder, second-degree murder, or whatever.
Mm-hmm.
But
so you're going to do something less, regardless of whatever the law is. It's got to be something less in your mind. Am I saying that right? I mean, that's okay, if that's what you think.
Yeah, I know that there's first-degree murder, second-degree murder, third-degree
Sure.
murder, all that kind of stuff. But if she was there, you killed her, she drove the car, she should be.
I didn't do the killing. She did the killing. I just drove.
Oh. But she should be charged with murder, you should be charged with first-degree murder, or whatever level charge is below murder.
Something less. Okay, what if I hired her to do it? Does that matter? I don't like that, clerk.
No.
Doesn't matter. I should still get something less. Trigger gets more.
You get less.
I get less.
Yes.
Okay. Anybody else agree with Mr. Conyers in the first row? Okay. Anybody in the second row agree with Mr. Conyers? You do? You think it has to be something less?
Yeah.
Ms. Gardner?
I mean, somebody can ask you to do something, but that doesn't mean you have to do it. So if you physically did it, then you should get the higher.
Okay. And if the law says that because I wanted the crime done and I hired her to do the crime, I should be as guilty, you cannot follow that law because you think I have to be something less.
Follow the law.
You will follow it. Okay. Mr. Conyers will do something less no matter what because that's what his conscience tells him. Yes?
Yes.
Okay. And that's the camp you guys fall into. That's Mr. Weaver and Mr. Gosline. Anybody else? My conscience tells me it's got to be something less. Speak now. Okay. I am getting to the end. May I have one moment, Your Honor? What about this? Okay. But wait, there's more. Does it matter to you, Mr. Fry, if, back to our scenario, liquor store robbery, if I am a witness and she's the defendant? Is that going to bother you? Can you, let's put it this way. Of course it's going to bother you. You're hearing from a witness who's a robber. Question is, can you keep an open mind to my testimony as a robber? Okay. Front row, can you keep an open mind to that type of testimony? I've turned state's evidence. They say that in the movies. We don't really say that. I'm a witness. It's her trial. Since I was the driver, I've cut a deal. I'm coming in and I'm going to say, I took her there. She went in and killed the clerk. That's what we planned. Can you keep an open mind to my testimony? Or would you discount what I have to say automatically because I'm a robber? Discount it completely. Anybody else feel like they couldn't even consider the testimony, my testimony, as a robber? In between, okay. Anybody else? Y'all consider it. I mean, you're going to consider that I'm a robber, too. You're going to consider that I have an interest because I'm trying to cut a deal and all that. But can you consider all those things, not just completely disregard? Yeah?
But if you were to turn state's evidence, wouldn't you get a lesser charge for turning state's evidence?
Does it matter?
If it's a law.
That's something you'd want to know about, right? Okay, what am I getting for it? Okay, I think that's a great question. That's something you can consider. But can you consider my testimony, including that? I got 20 years, and I'm here to tell you I took her up there, and here's what we did. Can you consider it? Nodding affirmative?
Pardon me?
You're nodding in the affirmative?
Well, I mean, you're complicit in having the crime planned.
Mm-hmm.
You didn't plan on a murder being committed.
Okay.
And she gets caught, you get caught. You get caught taking the gun, hiding the gun, or getting rid of the gun. You're equally as responsible because you both planned this act together. And then as you're arrested, you turn state's evidence.
Yes, ma'am.
For a lesser charge.
Yep. And will you be willing to hear what I have to say? I mean, I was there, right? Okay. In a conspiracy case, you're going to expect to have multiple people playing different roles, right? And you're going to have to kind of sort out who did the what. Can you do that? You're necessarily going to hear about the roles of people that aren't Mr. Adelson, that aren't on trial, because there's different people playing different roles, and we've got to sort them all out. Can you do that? Can everybody keep an open mind to that? Is there any particular type of evidence that y'all would expect to see in a case like this? Anything in particular you would require? I have to have the fill in the blank. If they don't bring me the fill in the blank, it's not going to be a murder case. Anybody? You have learned that it doesn't wrap up in an hour. Yeah, it's not CSI. We just have what's left behind. So there's no particular thing you're expecting to see, Mr. King, fingerprints, DNA, murder weapon. Would we agree that criminals in general try to not leave those things behind? Okay. Anybody feel like, well, what's better, direct evidence or circumstantial evidence? Direct evidence, so much better. Okay, why? Why, Ms. Moore? Mm-hmm. Mm-hmm. Okay, is the information direct or circumstantial or both? Okay, so the reason why I asked this is because, I mean, you guys played right into it. Direct is better, right? Direct is better, direct is better. And I think the answer probably should be it depends. So I have this really dumb hypothetical. Susie and Tommy are your children. When you come home, Susie and Tommy's mouths are both covered in powdered sugar. And the powdered sugar donuts are missing. Okay? And you say, Susie, what happened to the donuts? She says, Tommy ate them. She got it all over her. You say, Tommy, who ate the donuts? He says, Susie ate them. So, what's the direct evidence in that case?
Well, it doesn't sound like either one of them is lying. They're just not telling the whole truth.
Yeah. Frequently the case. Lying by omission. Okay. The direct evidence in that case is the testimony of Susie and Tommy. Both a little unreliable in this circumstance, right? At least partially. The circumstantial evidence is the powdered sugar, okay? So I illustrate that to ask you to keep an open mind to all types of evidence. Can y'all do that for me? Yes. Okay. Inconsistencies. I touched on this a little bit. If I pull you guys aside, which, Lord help us, I will not do this, one at a time and ask you to describe what happened yesterday when y'all were back in the individual voir dire, I would get a lot of different responses, right? If I asked even like, how was the table set up, the table arrangement, you wouldn't be lying, but you wouldn't all get it 100% accurate, right? Okay, there's going to be inconsistencies. Your job as jurors will be to weigh those and make a decision, is that material or not? Does that give rise to reasonable doubt or not? Only you guys as jurors can decide that, okay? All right. Appearances. What does a murderer look like? What does a murderer look like?
All they come in all shapes, sizes, colors, and they look like everybody else.
All walks of life? Everybody agree with that? Anybody find it hard to believe or impossible to believe that a family member could be in a plot to kill another family member? Is that possible? Can I have one more moment to confer, Your Honor? Thank you. All right. Other than it being advised that I still didn't succeed in naming Dr. Ravino, I have no further questions. Please accept my apologies.
I think it might be a good time to put them on a break before you get started so they can focus. At the same time, for where we're at timing-wise, I'm not going to step on your time, but it may not be the most effective use of time as we go later into the evening. Do you want to start tomorrow?
I'd like to start today, Your Honor. I can go make use of a half hour or whatever you give me. I would like to take a 5-minute break. I need to use the restroom, and so does my client. So,
very well.
What time does Your Honor plan on ending today?
Well, I was anticipating stopping by 6, but I don't think you're going to be done by then, are you?
No, So if I could go to 5:30, 5:45, whatever, Your Honor, I'd like to at least get started, though.
Does the state wish to be heard on the timing?
No, sir, I'll leave that up to Your Honor's discretion.
Very well, we'll put them on break. Before the defense begins to inquire, we're going to take a brief break. You'll have an opportunity to stretch your legs, use the restroom, look at your phones if you need to. Once again, I'm just going to remind you, please do not discuss the case with each other or anyone else, or look at any of the news coverage, or in any way look at what's been going on regarding this matter. Please come back to courtroom 3G in the next 10 minutes. We'll actually, I like round numbers, we'll make it a little bit longer. 5:10, please come back to the courtroom, and we'll get started at that point with the defense inquiry.
Oh, I saw it and I thought you were like,
Oh,
no,
okay.
I just saw it on your
Oh,
screen.
no, that's not what I meant.
That's not what
Yes, sir.
people to hear about.
For everyone that's in the courtroom, I'm going to have to ask you to step out during this break period. You can remain next to the courtroom doors, but I am going to need you to step out.
No, I'm okay.
Hard to say. For now, go ahead and have them report. If we're not done, we'll, I guess.
As you're watching Georgia Cappleman do the
questioning of the prospective jurors in jury selection, keep this in mind. The defense held it as a total surprise, this whole extortion theory, the fact that allegedly Mr. Charles Adelson was extorted by the actual killers of Dan Markel. So, that was a surprise move. Why did they do it? One of the reasons perhaps was to gain an advantage during jury selection, in the sense that the state had no clue that any of those issues were going to come up at trial.
Court is back in session.
Everyone can be seated. Before we bring everyone back in, timing-wise, it's probably best just to go ahead and let them know we're going to go for about another hour and then stop. If the defense is not finished at that point, we'll resume in the morning. I believe the clerk has already made arrangements to have a new batch of jurors that have not been examined, either individually or anything, to come in tomorrow if need be. We have them reserved, waiting in the wings as it comes to it. Are there any questions?
So about 6 o'clock, 6:15.
6:15, we're going to tell them we're going to stop for the night.
I won't be done, but I'll get as far as I can.
Right. State, do you wish to be heard? Please bring in the jurors.
I assume we're going to open tomorrow. That's
Yes.
the plan. Thank you, Your Honor.
Let's start at the left end. I'm having a problem at the wrong time of the day. That's all bad.
Oh, wow. Yeah. Surgery in December.
May I proceed, Your Honor?
Well, prospective jurors, before the defense begins its inquiry, you're going to advise you of the schedule for this evening. We are going to stop for the night at 6:15, and from there you'll be given instructions to report tomorrow. Neither party is going to be shortchanged as to the inquiry that you make. However, I am going to be respectful of the fact that you do have families and you have matters that you need to attend to. So once we've got to a stopping point, again, you'll receive your instructions and you'll report tomorrow. Mr. Dubin, the defense may inquire at this time.
Thank you. May it please the court. Folks, I'm all for a laugh. I spoke to many of you in the back, and I know that sometimes levity can break up a serious moment. But make no mistake, this is the serious of matters. There's no dispute about the fact that a man quite brutally lost his life. So I don't mean to alienate any of you or make you feel bad, but to this man, this is no laughing matter. And I'm not here to talk to you about powdered sugar on the faces or phony liquor store robberies. This man has pled not guilty. And with that plea, he's saying, I didn't do it. And stands here accused of a crime that he did not commit. So I would ask you all to please hit the reset button. And let's be mindful of what is at stake here. And I know from speaking to each and every one of you that you are. The one thing that has become so clear and that I've been so personally impressed by, my colleagues have, is how brutally honest each of you have been. It is not easy sitting in a room full of strangers that are poking and prodding and asking you questions, certainly those that are of a personal nature. I want to apologize in advance, and I want to tell each and every one of you that if I ask you anything that makes you even feel remotely uncomfortable, please, I extend this olive branch to you that with the court's indulgence, you can be heard in private. And if I say something that makes you uncomfortable and you don't take me up on the offer to be heard in private, accept my apology in advance. I'm just doing my job. As I said, I hope you can appreciate what's at stake here for Mr. Adelson. Is that fair? Okay. One thing we do agree on is that there is certainly bias can be a dirty four-letter word. We have violent agreement, if you will, on that. Certainly if it's about somebody's sexual preference, religious preference, ethnicity, religion, those are dirty, ugly biases. But we all have other biases, our value beliefs, our life experiences. The lens through which we've seen the world all forms the basis of how we're going to decide a set of facts. There are no wrong answers here. If you feel a certain way, and some of you have shared that about your faith, about prior experiences, please say it. Please say it. You heard the expression, if you see something, say something. Please say something. Nothing could be more important than you speaking up now. So with that being said, what is it? Somebody mentioned that they worked out. A couple of people were talking about the gyms they worked out. Planet Fitness has that logo, judgment-free zone. This is a judgment-free zone. Don't give me an answer just because you think I want it. or because you think His Honor or anyone else wants it, okay? Is that fair? Now, there are some people, and this is perfectly acceptable, there are some people that look at someone in Mr. Adelson's position, charged with perhaps the most serious crimes in our penal code, and say, you know what? Must have done something. Got to be here for a reason. And I think that most people that have been accused, arrested, especially of something that happened 9 years ago, they must be guilty, or more likely guilty. If you feel that way, that is fine. So I'm going to ask you, as I've asked many of you over the past day and a half, to please think about it for a moment and search yourself. With the court's permission, I'm going to ask Mr. Adelson to stand. Please take a good look at him. And if there's any part of you that looks at him and says, you know what? If I'm being honest with myself, because he's been arrested, charged, other people may have been involved, and he may have known them, that he must be guilty, or I lean toward guilt. You can sit, Charlie. Please, tell me if that's how you feel, even if it's a little bit that you're leaning that way. Dr. Rubino, do you feel that way at all?
Got a lozenge. That's why I was taking a deep breath.
Oh, I thought thought you were going to say something. Mr. Gosling, do you feel that way, even a little bit? All right. So if I could say it with stronger words, I would figure out a way to do it justice. I cannot thank you enough for having the candor that you just did in a room full of strangers. Thank you. So that's perfectly fine. Can you please tell me why you feel that way?
I mean, there's got to be some reason why he's here. There's something that people
Okay, and he is not going to be offended, and his feelings aren't going to be hurt. He wants this sort of honesty. So I appreciate your candor. Is it fair to say then, Mr. Gosling, that he starts out in your mind, you're leaning more toward guilt because he's here? Isn't that fair? All right, I appreciate your candor. Who agrees with Mr. Gosling? Even if you agree just a little bit.
A little bit in the sense of private flight, I think that the system kind of shows you a little bit of anxiety of being here and just kind of that's not to say what I believe that's kind of feeling like that.
And that's perfectly acceptable, and I thank you for your ability to be forthcoming about that and other matters, Mr. Weaver. Can't thank you enough. I appreciate it. Please, this is probably one of the more important questions I'm going to ask. Thank you. Thank you so much. Is it Ms. Williams? All right. So okay, fair enough. If you know me even a little bit, you know I'm gonna ask you some more questions about that. And just tell me the best you can to put words to that feeling. Please tell me what it is, Ms. Williams.
How did they do something that made it look enough like they should be in that courtroom in that initial
Okay. Understood. Was that almost hand raised or just moving your hand?
I disagree with the last three people, because of my personal experience. When I was a police officer, when I was 24, 25, 26, all those ages, there was that you can beat the rat, but you can't beat the ride mentality. And I really went around in my head thinking, and all of my friends thought, something must have got you here. Until the day that I was accused of something I didn't do. And I wound up with quote unquote guns pointed at me, meaning prosecutors looked at me, internal affairs looked at me. And it's the most horrible feeling in the world. And it destroyed my life. You could go down my line of friends, and as you walk down the line, see people jump on this side or that side. People that decided, you know what, you must have did it. People, some of them good friends, well, I thought were good friends. Some people that were just kind of not such good friends, just people I knew at work, where people put their arm around me and said, I'm on your side. But getting back to the point,
No, you can keep going.
I changed my mentality completely about you must have done something that got you in that seat. And honestly, for a long time, I was like, okay, now I'm on the other side. Now I don't believe the police, don't believe the prosecutors. But that was back in 1996, 97. And now as a person just a little older, a little wiser, I'm looking for what the proof is, what the facts are. And I went from being, yeah, you must have done something wrong and you wouldn't be here, to no, I don't feel that way anymore.
No, I can't thank you all enough. Having done this for a while, just to be able to have this kind of report, this honest report, is it's really the way the system should work. I'm gonna go down the line. It's such a critical question, and we have 4 of you who have shared your views on it. So I'm gonna ask you all again. I'm gonna stick with Mr. Gosselin and to some extent Mr. Weaver's point of view. Who else feels like, if you really search yourselves, sorry, I'm a wanderer, but I need to stay at the lectern because I don't want to suffer the court's wrath. How many of you feel even a little bit that based on, because some of you have read about the case, some of you listened to some things about the case, some of you have seen things on TV, heard others discuss it. Is there anyone else that feels like, I'm leaning, I hear you about the presumption of innocence. I know that's what the law says I'm supposed to do, but the way my mind operates is just a little bit different. That's fine. You're not going to get in trouble for that. This, my names aren't on my sheet. Ms. Parker? Okay. Do you feel that way about Mr. Adelson?
Well, I don't know about personally about Mr. Adelson, but I believe everybody deserves a shot to prove themselves innocent. They're innocent before they're proven guilty, until they're proven guilty. So,
forgive me for seizing on something you said, but does anyone know what I might quarrel with about? Yes, Mr. King.
He mentioned that he had a plea.
Does he? All right. These concepts, these ideals that we hold ourselves to as a society and hopefully individually, they only have meaning if each of you breathe life into them. So we could walk around kidding ourselves about these things unless we really believe them. So I'm hearing these things, but Ms. Brinkley, do you do you believe that Mr. Adelson coming into the room, if you really search yourself, do you feel like must have done it, must have been involved somehow?
Well, I can't give a yes or no to that because I haven't heard the case.
Okay.
Now, if I do become a jury and I hear the case, and then I can make my talk to the other jurors about it, and we go from there. But I can't answer that because I can't. By looking at him, I can't say, well, he's guilty or he's not guilty. I can't do that.
Forget about looking at him.
Okay. If
Just
I
based
look
on the fact that he's been arrested and charged.
I still can't say that he's guilty or not guilty.
Okay. Thank you. I appreciate it. What can you say?
I have to listen to the case. If I become a juror, I have to listen to the case.
Now I would ask you to take a look at him. What do you see over there? What is he now?
Well, I see a young man who's sitting in here, looking at the possible potential of jurors here, and
It was a poorly articulated question. If you don't look across this room,
I can't say anything.
no, let me get my question out.
Okay, go ahead.
If you don't look across this room and say, I see an innocent man sitting there, I want you to raise your hand, please.
Are you
Talking to all of you now.
Oh, why? Oh, well, I can't say anything.
How many? So, yes, Miss Parker.
Apparently he's innocent to me. I haven't heard anything that proves him guilty.
Who looks across the room though and says he's been charged, arrested? I look across the room and I don't see an innocent man. I see someone that has got a whole bunch of problems ahead of him. Does anyone feel that way a little bit? Sorry, I'm.
No, I totally. You have to be proven
Okay.
lie to get you right. And right.
And how?
But first of all, I didn't know him. Don't know him from James, John Doe, or whatever. So that's just like me walking into a room and somebody's judging me before they even get to
Right.
looking more than me.
How does it? How have you experienced that at all in your life?
In my line of work and just, just dealing with people because I deal with a lot of staff and just people make assumptions all the time about a situation that you don't know anything about.
Right.
So you already make an assumption before you even hear the details. And that's, quite frankly, that's unfair to the person and it's really is kind of slighted on your part. You not hear the whole full story. I still think you need to hear it back. And so just looking at someone across the room and saying they're guilty or guilty, there's no difference than you walking in the room and sitting right over in the same seat you sit. You don't know if I'm the person that's helping them, or you don't know if I'm just somebody just sitting there for support.
Thank you for your candor, Ms. Moore. Is there anyone that disagrees with what Ms. Moore said? Anyone? This is the last time I'm going to ask it because I don't want to go through each and every one of you. But Mr. Fry, do you feel like there must be something to it because he's been charged, arrested? Do you believe that? All right. I don't think it's any bolt of lightning to any of you at this point. Judging by the camera to your left and to my right, and as His Honor told you, that this case has received quite a bit of media attention. And this is totally fine if you feel that way. Any of you feel like you'd be a little bit reluctant to go back into the community, to go back to work, to face your friends, your significant other, anyone close to you, and say, you know what? I don't think the prosecutors met their burden, and I don't think that I could have found him guilty and vote not guilty if they don't meet their burden. Does anybody have even a little bit of reluctance there? that they would feel like, I don't want people to think I was part of a jury that acquitted Charlie Adelson? Mr. Jordan, would that be a concern to you?
No, I don't know anyone
All right. Who knows who on this panel knows someone that knows about this case? Okay. Mr. Brown. Okay. So I saw you, Dr. Rubino. I'm going to come to you in a moment. Who else, just by show of hands, is familiar with others that know about the case? So it's also Ms. Bell? All right. So starting with you, Mr. Brown, would you be reluctant if you found that the state didn't meet their burden to go back and face your significant other, anyone, and say, I acquitted Charlie Adelson? Why not?
because I would have been privy to facts and arguments that they would not have been privy to. I would have been through the trial where evidence was presented. Family, friends, whoever wouldn't have known that. And as a juror, you're entrusting us to look at that information and make a decision based on facts, not on what our friends and
How about you, Ms. Strong?
All right.
Ms. Bell?
I don't care. I mean, they weren't here to listen to observe, so they don't know what what I've done and been through. Listening to it, so they can't. I don't care what they think.
What about you, Mr. Fisher? You have friends in law enforcement, right? All right. Your friend, go ahead. Your friend, would you have any reluctance? Would you hesitate even a little bit if you felt like the prosecution didn't meet their burden to face your friends in law enforcement?
If they don't convince me with the evidence, I stand behind what outcome I would come to. You know, I wouldn't sway either way because I feel like it or because I'm being influenced. If they don't have if they don't show me the proof that it's rock solid,
Does anyone disagree? Does anyone feel like there'd be too much pressure? Or they'd be reluctant? Anyone at all? Ms. Walker? Mr. Brazos? You were a juror before you were a foreman, right? All right. You were kind of in charge of keeping the trains on the tracks, right? Making sure that people were able to say their piece. Fair enough? All right. There was a verdict in that case. And you feel like that experience would have any impact on you sitting as a juror in this case? Why not? Okay. Before I move on, Mr. King, anything to tell me? You, I don't know. We keep making eye contact. I figure I'd call on you now. There wasn't anything specific. Do you, you're confident that you could look across the room and not just when the trial starts, but through the trial? I mean, I'm not going to instruct you on the law. I wouldn't dare. His Honor is going to instruct you on the law. And if I'm wrong on it, don't hold it against Mr. Adelson. But I have an inkling I might be right on this part. What if you were to learn that the presumption of innocence is like a thread that you grab onto right now and you pull it all the way through the 2 or 3 weeks of this trial? In other words, that every time you look across the room, that you presume Mr. Adelson innocent. That's not an easy thing. You've heard of the expression innocent until proven guilty? Let me modify that. Innocent unless proven guilty. Until sounds like an eventuality. What's the difference between what I just said? Innocent until proven guilty versus innocent unless proven guilty, Ms. Spates. Okay, but I wanted Ms. Spates to answer it. That's all right. I looked in your direction.
Until means to me like you are continuously trying to prove this point.
And what does unless mean?
Unless means you may not be.
Okay. Can you appreciate the point I'm making? Does anyone disagree? All right. I'm going to move on to a different subject. I think that Ms. Williams mentioned it. How many of you, by a show of hands, have heard of people being exonerated for crimes that they did not commit? By a show of hands. And by my count, that's all of you except for one. That's all of you. Except for almost one. All right. We hear about these stories when? When do we hear about those stories, Mr. Conyers?
After the trial. After the trial.
After the trial. After what?
After years of incarceration.
All right. All right. So they're nice stories, right? But they aren't nice for the person that went through it. So I'd ask you, do you feel like, is there anyone that doesn't think they can keep that in mind throughout the trial? So in other words, once that happens, it's too late. That's how serious this is. Does anybody think, you know what, I'm going to have a difficult time as witness after witness comes in and testifies during the prosecution's case? I might have a tough time looking at Mr. Adelson and continuing to presume him innocent. Please, there's got to be someone amongst you, because we've had people come back and tell us that they've read about the case, and when you're hearing one side, it can have an effect on you, right? Does anyone think that they might have a difficult time continuing to remind themselves throughout that I have to presume him innocent? Unless. Anyone feel they would have a difficult time with that? Who haven't I called on? Can you show me? I've called on everyone. Didn't feel like it. Who might have a difficult time with that? Ms. Brinkley, do you feel like you'd be able to do that?
Repeat the question again.
Will you be able to continually look over at Mr. Adelson throughout the trial, even as the prosecution brings in witness after witness, and continue to say, I hear you, but I have to view him as an innocent man until I hear the instructions on the law, and unless, after I deliberate with my fellow jurors, unless I find him guilty beyond a reasonable doubt?
Once again, I have to listen to the case. I can't say he's innocent or guilty. When I come in here, I have to listen to the case. I'm not going to look at him and say he's innocent until proven guilty. I don't know. I have to listen to the case.
Fair enough. I appreciate your candor. Does anyone agree? That was as honest as you can get. She said, I can't look at him and presume him innocent. That's okay. That's fine. Who agrees with that? Who agrees that I'm not going to presume one way or another? I don't care what the law says. Anyone else agree with Ms. Brinkley? Mr. Fry? Okay. Does anyone agree even a little bit? Okay. How many of you have heard of Nancy Grace? All right. How many of you are a fan of her shows? Beyond? Okay. Who can you just keep your hands up just for a moment?
Wait, heard of her or watched her?
How many of you have watched her shows? Ms. Gardner? Have you watched her shows?
In the past, yeah.
Okay. And what was her point of view? Typically.
She's always very firm, and her beliefs are always very clear.
And what are those beliefs usually clear about?
I mean, it just depends on what's going on, what she's reporting.
Thank you. Ms. Strawn, what are her beliefs typically? How many of you agree that have seen her shows that that's how she sort of... So tell me, and this is fine if you feel this way, whether you find her entertaining or whether you agree with her. How many of you are a fan? A regular watcher? Okay. For the folks that work for the state, for a municipality, are there any of you that feel, and there were several of you, that either work for the state or have family members that do? Do any of you feel like some simpatico, if you will, some familiarity with the prosecution because they too work for the state? Who works for the state? Okay. So I'm going to start with Ms. Walker. Remind me again.
I was an adjuster for 38 years.
Okay. Different area.
It was all workers' compensation.
Okay. Any particular allegiance with the prosecutors here because they too work for the state? No. I believe Ms. Gardner works for the state, yeah? Okay. Remind me of where you work at the state again.
Agency for Healthcare Administration.
Okay. And do you feel like when you look at the prosecutors, any bit of, we're all in the same gang kind of thing?
No.
You sure?
Yes.
Not a little bit?
No.
All right. Who else? Okay. Do you understand why this might be a concern for me, Dr. Rubino? Okay, why?
Because if we're inherently biasing ourselves towards a certain group, we might also bias ourselves towards their opinions.
Yes. Spoken like a true scientist.
I'm nerd, I can't help it.
Well, you're preaching to the converted. I'm just a nerd for different things. Mr. Fry? Oh, sorry. Fry, Fisher, separated by a column. All right. Now you got that in my head.
Yeah, no allegiances.
Okay. All right. Anyone feel that way that have family members that work for the state? So Dr. Rubino mentioned something that I'd like you all to consider. This notion of inherent bias. And it's something to think about because I have a little bit of ways to go. It's something to think about overnight. If there's anything that I asked you about that you reconsider to yourself, not on the internet, not to a friend or to no one but yourself, please let me know first thing in the morning. Had that happen where someone comes back the next day and says, I thought about it, and I kind of do think I might be starting off with Mr. Adelson a little behind, or I might have allegiance to the prosecutors because they work for the state. How many of you prior to today had heard of the talented prosecutor, Ms. Cappleman? Okay. Mr. Brown? Okay. How would you heard of her? Oh, the baseball, Little League. Come on, I was looking for someone that...
Well, and I've seen her name in the newspaper on TV.
Okay. Had anyone else heard of Mrs. Cappleman before today? No? Okay. How many of you have had pleasant experiences with law enforcement? Okay. I'm going to start with Ms. Parker. Tell me about that.
Well, I used to be president of the Broward County Managers Coalition, and we work hand in hand with the Broward County Sheriff's Department.
Was that on Federal Highway or on Sunrise Boulevard? Is that where you were?
Well,
was it on Sunrise past Federal Highway?
It was Deerfield, Boca, between Deerfield and Boca.
Okay.
But this has been many years back.
Okay.
The Sheriff's Department would work with us in conjunction with whatever we were trying to address as far as problems in the area. Break-ins, robberies, evictions, a lot of different things. And they were always very helpful, and they'd come to the meetings. And
Okay. I appreciate you sharing that. Mr. King.
Just Deputy Eldridge made the past day and a half pleasant.
Now, I should have known better than to ask the question without a specific caveat for Deputy Eldridge, because I, too, love the man. And I mean that, but before you met the fine deputy. So in other words, here's what I mean by it. Maybe this will help me get a little more specific. Whether it was when you were pulled over and, the officer let you off, or whether it was because I know that there was a few people who had homes were burglarized, or, you needed help with directions, whatever the case may be. How many of you walked away and said, that was a fine police officer? In any situation. Okay. All right. Great. So tell me about that. Now I'm going to get it right. Mr. Fisher.
I've had a few encounters with law enforcement.
In what capacity?
Either being pulled over for like a tail light out or something like that. Nothing serious or anything. I don't think I've ever had a real bad experience per se.
Okay.
To my recollection, it wasn't. You're polite, they're polite.
Who else? Mr. Braza?
Yeah, I mean, I've had good and bad experiences, but just like anybody else, what I was saying, different jobs for probably 45, almost 50 years. So, I've had good experiences. That's why I was so happy.
I don't want to talk about those. I only want to talk about the times where you walked away feeling like this person really helped me and made a difference in my life. Just by a show of hands. All right, perfect. So, Ms. Strawn, tell us a little about that. You had a double who? Oh, double doozy. Right. Were you conducting surveillance or just?
I was just following.
Oh.
We were excited because my son, that was the only time he got on the roll. We were really excited. The only day.
Right.
So we're going to get something to eat. And we come around the curve and there's two highways on and they pull us over. We were going 55 and a 35.
Okay.
But they just said, but that would have really hurt.
Ms. Daigle, I think you raised your hand as well, or no?
Well, I mean, just being pulled over, being let go.
Now, I want to call you James Jordan, but it's Jordan James, right? All right. Mr. James, did I hear you right? Did you say your dad was a sheriff?
Law enforcement.
At the Jacksonville Sheriff? And you're not raising your hand?
No, because, he always says every occupation is different bad people.
Okay. So for the folks here that have had, I know that you raised your hand as well, Ms. Moore. Was it in relation to anything other than like a traffic stop?
Yes, there's when we have certain things that match up in my organization, lately it's been like,
Oh, I'm sorry.
but, it happens, we all live in.
I hate thinking about that part. Though.
They come out and they direct the traffic and they're really, helpful with even the family that has lost a loved one. And then they'll do stuff, it's in Jasper County, so they'll do stuff with the kids. And they'll come out and they'll support, so it's been a really good experience.
Okay. So I'm going to put this question to Ms. Strawn and Ms. Moore. But I want you all to act like I'm asking you all right? But you were the two that mentioned, particular instances. You with the help with, the unfortunate event when somebody passes, and you with the double doozy. I expect there to be law enforcement that will take the stand here. And I know that my colleague on the other side asked you some version of this question, which was that how many of you would give them any more or less weight? I'm asking you, do you think in light of your positive experiences with law enforcement that, I know that Mr. Gosling was extremely candid about this, and he said, yeah, hold them to a higher standard, and I think that they're more credible than an ordinary witness in words or substance. Do any of you think that? In other words, when a law enforcement officer takes a stand, that you look at them as being more credible, more believable, more reliable than another witness. How many of you feel that way? I know we already got you, Mr. Gosselin, you, Mr. Weaver. How many of you feel that way? No? Why not, Ms. Moore?
The reason why I said I didn't raise my hand is because I think they're an individual person and you have to look at people on an individual basis. And I still have to see the person for who they are. And so I don't, that by them being a law enforcement is no different than, you can take an example of me looking at your arm and holding him. We do look at the person based on the position and hold them in high regard, but at the end of the day, they're still individuals.
Okay. Does anyone, I know I have some points of view in the front row that may or may not be from someone that played for the Reds and then went to the Mariners and went to the Yankees. And from Mr. My son's a big fan. And from Mr. Gosling. Did I have that right? All right. I think you had a good season. Does anybody feel that someone gets on the stand and they're wearing a uniform or they're part of the Leon County Sheriff's Office, that they must be more believable? All right. How many of you have heard of this notion of something called groupthink? All right, groupthink. Can can the good doctor explain?
If I recall, groupthink is the idea of people jumping on one person's idea and following up behind that. So lack of independent thinking, humans tend to conglomerate around ideas. It's how we develop kind of group positions on a thing, and it repeats itself over time.
Okay. Can you give me an example, Dr. Rubino, of how and when groupthink can be a dangerous thing?
I think anytime a person is in a position of leadership and they're trying to manipulate a crowd to lack the individual critical thinking needed to assess a position. We've tried an example of when somebody is trying to move a group of people in one direction. you know, it sounds nefarious, but it can be as simple as you're a coach and you need to get your players to all believe in the same mission. So it's kind of structured into leadership.
So let me, Dr. Rubino, thank you. I might reference you again when I need to articulate something better than I know I'm capable of. So, you know, there couldn't have been a better explanation, I don't think. So what I'm getting at here is, how many of you think it's possible, or let me switch it, how many of you think it's impossible for a group of well-intentioned people to take the witness stand, all for one reason or another believing one story, but they all got it wrong? Does anyone believe that's impossible? Do you follow my question? Who's confused about my question? Okay, only one. That's not bad. So, what do you think I'm getting at, Ms. Williams?
Getting at perhaps what leads to this thing or possibility of somebody hearing the same story of being wrong is questioning themselves maybe, or hearing other opinions, or you know, questioning what they thought they saw because somebody else said they saw this, and then making you think, well, is that what it was, or did I see what I thought I saw?
So in other words, you know, it's too late. The hour is late, and your attention blows my mind. The fact that you're all still making eye contact and with me. So let me just get right to the point on this question. How many of you think it's impossible for one after another, witness after witness after witness, to come in here and all tell you a story that points in their minds to this man's guilt? Do you think it's impossible for that to happen and then for all to be wrong? Why not, Dr. Rubino? Why is it possible that they're all telling the same story or have a certain point of view, and yet they could all be wrong?
They could spend a lot of time talking to each other. They could have shared values, they could have shared a lot of information back and forth between each other. They could have a shared perspective on the world that assumes a certain level of guilt or innocence.
Thank you. Ms. Strawn? Or let me go to Mr. Fisher.
It's a false memory fallacy.
Okay, tell us what the false memory fallacy is.
False memory is basically, if you're asking somebody if the perpetrator, you know, what shirt were they wearing? They say a green shirt. And then later on you say, but what about the red shirt that they were wearing? And you can slightly alter the way until the point where they said, yeah, they were wearing a red shirt.
How many of you say, you know what, Dubin's crazy? No way that this happens. No way that so many people all think the same thing and have it all wrong. Do any of you feel that way? I know Mr. Gosling raised his hand earlier. Do any of you think that? Think that's possible? Or you all leave open the possibility that they all think a certain way, whether it's groupthink or the false memory fallacy, and they just got it wrong?
I don't know what it's like to be in that field. I think there's a lot of times, some development at the elite level that they want to do that. So I don't know if it's possible or not, but I think in that aspect, you can be rewired to think similarly about it.
Anyone disagree with that? All right. Yes.
Help me understand.
Yes, sure. If I can, I'll try.
So if there's 12 people that saying the same thing and agreeing on the same thing, so, oh my God, I forgot what I was going to say. So if there's 12 people that is saying the same thing and they're saying that he's guilty, you're saying, your question is to us, do we believe the 12 people?
No, I'm asking something different.
Okay.
All right. And here's, I'm going to give you a hypothetical that doesn't involve a crime.
Okay.
I'm not going to make anybody the perpetrator or my co-conspirator.
Okay. Help me understand.
All right. If 10 people get up here and say, I see a microphone in that, excuse me, it's late in the day for me too. If 12 people get on the stand and say, I'm looking at Josh Dubin and he is not holding a microphone in his hand. But what do you see?
You're holding a microphone.
You just exercised free will, didn't you? You're not going to believe the 12 people. You're going to believe what
I
says.
see, yes.
That's what I'm trying to say.
Okay.
All right? Does anyone feel like no? I mean, Mr. Weaver points it out. They may know a little bit better. They were trained to be at this elite level. You're all the ones that are going to be here deciding Mr. Adelson's fate. Not the witnesses, not Mr. Rashbaum, not Ms. Myers, not the prosecutors, you. You're the ones. Is anyone uncomfortable with that? At all? It's a big responsibility. Mr. King, are you comfortable with that? Anyone the slightest bit uncomfortable with that? Do you understand where I was coming from now? All right. I have one last question for the end of the day, and I cannot thank you enough for your attention to this and your patience. How many of you love to go to the dentist? Love it.
I love my dentist.
Yeah.
Okay. Please, by a show of hands, who loves their dentist?
I love the feeling of clean teeth.
You loved your dentist, but you don't like to go. All right. All right.
Lifelong dental trauma. My dentist is the best person on the planet. I love the feeling when I read it.
All right. Who else? Okay. How many of you are like my 3 children? Well, at least 2 of them. How many of you say, you know what? I cannot stand the dentist. I hate going there. By a show of hands. Okay. Can you all put them up high so my colleagues can... All right. Because I'm going to ask you all. Mr. Adelson is a dentist. You can put your hand down now. Sorry. Mr. Adelson is a dentist. Do any of you feel, we're looking across the room a lot, those were my hypotheticals, right? Do any of you feel that, these dentists, they cause me anxiety, it's painful, I don't like it, and therefore that will somehow transfer, even if it's a little bit. Even if you're like, oh, a dentist on top of it all. Does anyone feel that way? Mr. King, your hand flew up first.
It's not his fault.
What, that the practice of dentistry is painful to humans, or?
Yeah.
Okay.
I'm the one responsible for the care of my teeth.
Do any of you have such negative feelings about dentists or had a negative experience about dentists that you might view Mr. Adelson negatively? Have any of you ever read anything negative about dentists? Ms. Parker, we haven't chatted in a bit.
I don't feel strongly either or. If I dislike the dentist or I don't like the dentist, or I like the dentist. If I have to go to the dentist, I got to go to the dentist and get it done and take care of it.
Ms. Spates, how's the dentist for you? Okay.
I don't dislike a dentist. I leave them, they get the job done, and I'm pleased with it.
I'm not going to belabor the point. I just wanted, had it happen before where someone's like, they're that occupation. I just got a negative vibration, and that's that. All right. No one feels that way? All right. I said it was my last question, but I am in His Honor's domain, so to speak. So I see that we're going to 6:15. I have 3 more minutes. Is it all right if I squeeze in a few more?
Well, you're gonna be on a hard count, but it's cool to do.
I'm gonna pick the one that causes me to have a soft win. How many of you feel that everybody deals with death the same way? Okay. Who here has an expectation about how someone should act when they hear that a family member has passed away? How many of you have experienced the passing of a family member and one of your other family members doesn't cry?
Yeah.
Okay. How many of you found that odd? How many of you found it odd, weird? How many of you have had the experience when a family member passes away and the other family member gets right back to their normal routine?
Everybody handles their grief.
Okay. What about funerals and memorial services? Is anyone here, if you hear that Mr. Adelson did not attend the funeral or memorial service of the victim, how many of you are going to say, that's suspicious to me? Any of you? Why not, Mr. Jordan?
I mean, I know me personally, I don't like funerals, so if I can skip out on one, I'll skip it out.
Even if it's a family member?
If it's someone I'm not close with, I will get out of it.
Yeah,
Who disagrees and says, you know what, I'm always going because it's the respectful thing to do? It's fine if you feel that way.
I'll do that for direct family, but there's certain extensions or.
I'm going to pick up on this tomorrow. Ms. Brinkley, you sat up in your seat and you're inching closer.
I didn't go to my grandmother's funeral, and I didn't care what the rest of the family had to say about it.
Why not?
Because I wanted to remember her the last time we had a conversation. I don't have no knowledge of her being in a casket. And there were other family members that, that's a shame, you shouldn't have done that, she raped you. Look, I don't care. I want to remember her the last time we spoke.
All right, now I'm going to let go of the mic because it's 6:15. Thank you so much for your time. Yeah, I appreciate you very much, and I'll be speaking with you again bright and early.
Okay.
All right. Mr. Dubin, as to that last question that you asked, this is essentially a fact that the prospective jurors might not have known concerning this case. Is there a reason you got into that subject matter?
I'm not following you. The fact that he didn't attend the funeral.
Correct.
This is why I came up at sidebar earlier.
Testing your theory of defense, that's one thing. The facts of what will be presented as the evidence, that's completely different.
I'm going to be very clear with the court why I asked it. I think that there's plenty of people out there that would hear that someone did not attend a funeral or memorial service, and then there's standing trial for that person's murder, and would say, you know what, I find that odd. And if I overstepped and didn't do it as hypothetical, it certainly was not intentional to inject a fact. But there is little doubt that that is going to be evidence that's presented here. I thought that, in my mind, it was part of the theory of defense, is that there was a reason why he didn't go to the funeral. It has nothing to do with him having been involved in any way with the murder. Can assure the court I will be much more careful tomorrow and phrase it as hypothetical. As Your Honor knows, I have deep respect for the court and did not mean it to come across as injecting a
areas of inquiry that are proper certainly are your theory of defense, whether they can follow the law, testing bias, but as far as getting into specific facts that will be a part of the evidence itself, not proper. Alright, for tomorrow, how much longer do you think you're going to inquire still of the jurors?
Of this panel?
Yes.
40 minutes.
Very well. From there, we'll retire to the jury room to go through any strikes, and if we have to reload the panel, we'll do so with the jurors that have been listening in the gallery the entire time. We still do have some jurors that are going to report tomorrow. Hopefully, if we're successful, we won't need them, but we'll still have them on tomorrow and Thursday if necessary.
Can I clarify one point about the jurors, about the judges' jury selection procedures? Because I was not at the pre-trial conference. When we go back, whatever strikes we exercise on this panel, whoever we don't exercise a strike on, there's no backstriking, correct?
Well, the law prevents backstriking, so if you get down the line, you can backstrike.
Okay, thank you, Your Honor. May I inquire, when we reload, if we reload, will we reload the whole box, or will we keep the keepers?
We're going to just shift down in position whoever is remaining. So if we end up, hypothetically, say we're keeping 7, 14 are leaving, then they will become the first 7 on the first row. The new 14 will be in the 2 rows behind them.
Are you open to negotiating that plan?
We can discuss it further tomorrow, but if need be.
Okay. I hope the court accepts my sincere apology for overstepping in any way. It was inadvertent.
Apology accepted. All right. As previously stated, we are going to go into recess here for this evening. The defense is going to continue with its inquiry tomorrow morning. You will need to report by 8:30, and from there, one of the assistant clerks will bring you all to this courtroom once again. For everyone in the gallery, you will also need to report at 8:30 tomorrow, and you will be brought up as a group. Again, it's very important, although you are not the ones that are being questioned at this time, that you're paying close attention to everything that's going on, because if we are not able to select a jury out of this group, from that point, we are going to be summoning people from the gallery to come and fill these seats and continue with the process. The instruction that you have received previously about not discussing this case with anyone else, not reviewing any news reports, or seeking any information on your own, that remains in place. This is very important to selecting this jury, that no one is breaking that court order. Again, do not discuss the case with anyone. Do not seek out any information on your own. Do not watch the news or seek any other additional information. Have a good evening. We will see you tomorrow morning and continue with the group for diary.
Nice as 9.
Sleeping in. For the other group that's coming in that's never been qualified is the separate courtroom. I guess it's 1A that we start off at. Okay, if you can use separate courtrooms. Yeah.
Yeah.
No. I'm gonna do one. It's different than everyone else. The way I do it. Here's one.
One more minute. Do we have anything else that we need to address just with the parties before wrapping up for the night? Anything else to address with the parties before we wrap up for tonight? All right. We're in recess. Please report by 8:30 tomorrow. Hopefully everyone's on time and we can get rolling as quickly as possible. The jurors who are reporting who are not qualified, we're going to try to keep them in a separate space so that way they will not be mingling with the ones who have already made it to this stage, possibly infecting any error into what has gone on. So I will see you tomorrow morning. Have a good night.
We have obtained over 10 hours of exclusive jury selection footage from the Charles Adelson trial. Part 2 is coming soon. We hope to see you there. Thanks for watching Mentour Lawyer and Ladybug.